Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti.
And I'm Christina Ma. Today, we dive right into part 2 of Our Curious Amalgam Fireside series, where we bring together staff of Our Curious Amalgam and commentary from the Antitrust Law Section committee members for 2020 year-end review and 2021 preview. Sergei Zaslavsky, the producer for this OCA series, is here as our guide. Sergei, welcome.
Hi, Christina.
So what are we doing today?
So today we're going to listen to submissions from 3 ABA Antitrust Law Section committees. We got Josh Chad from the International Committee, Veronica Canton from the Privacy and Information Security Committee, and Lauren Aronson and Jenna Kramer from the Consumer Protection Committee. But that's not all. Also, we have a couple of our regular hosts joining to provide commentary and help us make sense of it all. We're very happy to welcome Matthew Hall and Kayla Odom. And with that, let's dive right in and listen to Josh Chad of the International Committee.
Hello, listeners of the Our Curious Amalgam podcast. I am Josh Chad, one of the vice chairs of the International Committee, and I'm here to provide a year-in-review report. As much as I would like to be able to summarize and condense the entire year in global antitrust developments into 3 minutes, I fear that the world is too big and that I am not able to speak quickly enough to capture every important update from around the world. Instead, I will focus on 2 key trends from this past year with a view to looking forward to see what we can expect for 2021. The first is intensifying global scrutiny of big tech, and the second is hipster antitrust, including data portability, sustainability, and privacy issues. Let's get into big tech. Over the past year, we've seen an increased focus from antitrust enforcers on big tech companies, namely Amazon, Apple, Facebook, Google, and Microsoft. In the US, this includes investigations by the House Judiciary Committee, the FTC, the US DOJ, and state antitrust enforcement agencies. Some legal complaints have already been launched, with others reportedly on the way, targeting everything from monopolistic practices, including the treatment of third parties in online marketplaces, past acquisitions, distribution arrangements, and more. Competition authorities around the world are considering similar investigations. As well, in China, antitrust guidelines announced in November by the State Administration for Market Regulation aimed at curbing monopolies in big tech have caused China's biggest tech companies to shed almost $290 billion in market value. The new rules cover areas including pricing, payment methods, and the use of data to target shoppers. The rise of concerns about killer acquisitions, that is, buying up startups before they become rivals, is an aspect of big tech's alleged dominance. This practice raises questions about competition law enforcement, such as whether notification thresholds should be revised to capture these smaller deals, as is being done in Austria and Germany, and whether the substance of merger reviews should be changed to incorporate issues posed by killer acquisitions, which do not typically raise competition concerns under current frameworks. One alternative is to consider dynamic counterfactuals, such as being done by the UK CMA, which measures a deal's impact against how the market is likely to develop in the future. In the US, the FTC is reviewing acquisitions made by big tech companies from the past 10 years that fell below the HSR thresholds. As we look forward to 2021, it is clear that investigations into big tech will continue to dominate the antitrust world, with potential implications in the approach to monopolistic practices, merger reviews, and more.
Well, that was a good summary from Josh. And I understand that there's some interesting recent news out of Europe on big tech. I drink about 5 cups of tea a day, so I think I'm pretty qualified to comment on Europe and the UK. But just to be safe, we decided to bring in a real expert, Matthew Hall. So Matthew, can you tell us about the Draft Digital Markets Act and how that relates to what Josh was talking about?
Sure thing, Sergei. Hi. As you say, Josh, he spoke fast and he covered a lot. So I will try to at least cover some elements. You mentioned the Digital Markets Act. This is actually going to be complementary to competition law. So it's a separate and parallel regime which was announced as a proposal by the European Commission on December 15. And this is going to put in place ex ante rules or prohibitions for certain digital platforms, gatekeepers. So your Google, your Facebook, your Amazon, but not only them. In fact, it has a fairly wide scope of application going beyond the GAFA companies. There's some very interesting points. I just can flag up just a few of those. Quite significant sanctions for infringements of these prohibition rules, up to and including structural measures. So divestments ultimately are considered in this document. And just looking at some of the problematic practices that have been flagged up, things like unfairly using data from businesses operating on the platforms. So think Amazon, there's going to be a prohibition on that. Situations where users are locked into a particular service, so think of Facebook and data portability. There's going to be a requirement for data portability. And blocking users from uninstalling pre-installed software. That's going to be prohibited. Think, of course, of Google and Apple. So there's going to be a lot of argument about the Digital Markets Act in the EU in 2021. A lot of lobbying, so let's see where it goes.
Very interesting.
Matthew, it is interesting. I really want to make 2 points here. First is, look, Europe has been ahead of the U.S. on enforcement in the big tech space. We'll see what happens in the U.S., but I think a lot of the criticisms you're hearing on Capitol Hill from both sides of the aisle really suggest that people would like to see more enforcement in the space. And like I said, Europe has been doing that for a while. The second really is a point to Sergei made earlier. With all due respect, my friend, tea was discovered in China like 5,000 years ago. So drinking tea gives you no qualifications to speak on Europe.
I agree, John. I'm qualified to speak about Chinese law as well.
I agree with you. Matthew, golf was discovered in Scotland. I mean, come on.
Well, the Chinese claim it, but anyway.
All right. Well, with that, let's turn back to Josh.
Next, let's get to hipster antitrust, including data portability, sustainability, and privacy. The hipster antitrust movement is characterized by calls for non-price consumer welfare effects to become the focus of antitrust law. While it may be a while before non-price effects become the main focus of antitrust law, it is certainly possible that non-price consumer welfare effects will be given greater weight as public opinion shifts and as antitrust remains in the global spotlight. Data portability has been a hot topic recently, with many jurisdictions considering barriers to entry caused by consumers being unable to readily move their data from one competitor's product to another competitor's product. For example, in the EU, Article 20 of the GDPR provides the right to data portability, and in the US, the FTC held a data portability workshop this past September. In terms of sustainability, the EU is calling for submissions about the role, if any, that sustainability should play in competition law. As well, the Dutch competition regulator issued draft guidelines for sustainability agreements that outline special considerations when competitor collaborations have sustainability effects. There have also been calls to consider sustainability objectives when analyzing mergers with sustainability benefits. Privacy is another hot topic in terms of its relevance to the analysis of competitive effects, which directly ties into the focus on big tech that was discussed earlier. One aspect being considered in the UK, Germany, France, and other jurisdictions is whether privacy policies implemented by big tech companies can constitute an abuse of dominance, particularly where these platforms are funded by digital advertising that relies on receiving consumer data. In 2021, it is safe to expect these non-price effect movements to continue to gain support, and it will be interesting to see where they have the biggest impact on the law and on global antitrust enforcement. Just quickly, some other key trends. So in addition to the two main trends I discussed, other trends from this past year and looking forward include delays that the pandemic caused in the usual timelines for antitrust enforcement activities, an expected increase in failing firm arguments and merger reviews, preparations for Brexit and the risks that will be associated with parallel enforcement of competition law matters by both the UK and the EU, and the long-term impact of antitrust authorities' permissive attitudes in 2020 to competitor collaborations that responded to the pandemic.
Well, Josh talked about hipster antitrust and sustainability. Matthew here is a resident hipster. So we're going to ask Matthew to expand a little on the intersection of sustainability and antitrust.
Well, thanks, Sergei. I'm not sure about the hipster element, although I have grown a little beard over the lockdown, so maybe that helps there. But Yeah, on a serious note, I think on the sustainability side, that's rapidly moving right into the mainstream in the EU and the UK. It's not really any longer hipster antitrust to talk about sustainability, at least in terms of environmental sustainability and its application to competition law. And this is really across the piece. We're talking about state aid or subsidies, merger control, and as well as antitrust or competition enforcement. And the regulators are recognizing in the EU that they need actively to help companies to do what they can to reduce their greenhouse gas emissions. Josh mentioned the EU consultation. This is a pretty big issue in the EU in 2021. This is the application of competition policy and how it interacts with the EU Green Deal, which is the EU's effort to become net zero by 2050, although I think they're trying to move that earlier in terms of overall greenhouse gas emissions. There's going to be a big conference in February looking at the submissions that were made in response to that consultation. Josh covered a few other comments in this area, but just one point to make, I think, is that state aid or the EU subsidies rules have really been in the lead for some time already on the sustainability front, with a lot of scope for governments to aid companies in their environmental efforts. And looking forward to 2021, I think it'll be interesting to see if we get some real life cases in this area. For example, a merger where they're trying to argue that efficiencies benefiting the environment might balance potential price increases and therefore allow a clearance on that basis. We will see if something like that pops out of the woodwork.
That will be very interesting to see. And I'd be curious to see what happens on the other side of the Atlantic, too. Environmental protection is expected to be a bigger priority in the U.S. in the new administration, of course. So it'll be interesting to see how that overlaps with the antitrust and whether U.S. will look to the EU as kind of a model to follow in that area. So good stuff. Well, with that, why don't we turn to Veronica Canton, who is going to provide an update on behalf of the Privacy Committee.
Two trends in privacy and information security in 2020 were the passing of the California Privacy Rights Act, CPRA, and the data security challenges of remote work. And in 2021, individuals and businesses should look out for the increased impacts of new international data privacy laws. On November 3rd, Californians voted to approve the CPRA. The law enhances the CCPA by imposing stricter protections on consumer privacy, similar to Europe's GDPR, and adds requirements for businesses. Importantly, the CPRA applies to businesses that derive 50% or more of their annual revenues from selling or sharing consumers' personal information, increases the CCPA threshold for the number of consumers to 100,000, and distinguishes between two types of advertising: cross-context behavioral advertising and non-personalized advertising. Next, increased remote work in reaction to coronavirus created a hidden challenge: data security. Every business needs to protect its data and documents, but the human element can undermine even the world's strongest security system. Thus, data privacy awareness training became a staple of most organizations. Privacy and security teams are no longer solely responsible for data privacy. Now, HR, customer service, marketing, IT, and sales team also share this responsibility, as their departments process high volumes of personal information. Normally, these types of employees were rarely involved in compliance activities, but now require routine, practical training to equip them to take on these new responsibilities. Finally, we expect to see the impacts of more international data privacy laws in 2021. In Europe, this would include implementing the new draft standard contractual clauses and compliance with the European Data Protection Board's Schrems compliance guidance, as well as dealing with Brexit and its data protection implications. And we are anticipating new privacy legislation in India, Canada, and China based on, and at times going beyond, GDPR. as well as the implementation of new privacy laws in Brazil, Barbados, Panama, Kenya, Nigeria, and Egypt.
It's an excellent summary from Veronica. And let's bring in Kayla, our resident privacy expert. Now, Veronica talked about California. Can you fill us in really quickly about what's going on in the rest of the United States?
Hi, Sergei. So other states in the U.S., they've been watching the privacy legislation play out in California. So California's privacy law came into effect at the start of 2020. A lot of experts described it as a compromise at the time, and it might not have been as comprehensive as some would have liked. Well, in November, Californians like myself voted to pass a supplemental law, the California Privacy Rights Act. And Veronica highlighted aspects of the new law and how it adds to the protections of the CCPA. So as U.S. companies that have business in Europe have worked to become compliant with the GDPR, and now California's privacy laws, it may just be a matter of time before we see something at the U.S. federal level or in other states. We are seeing more states pop up into the conversation when it comes to data privacy. Nevada and Maine actually already have privacy laws in effect. And some states like New York, Maryland, Massachusetts, and Hawaii, to name a few, have drafted their own privacy laws similar to that of California's. Some even go a little bit further in terms of the privacy rights that are protected. At the federal level, what we have right now are various sector-specific privacy laws, for example, HIPAA in the healthcare industry, the Children's Online Privacy Protection Act. We've also got laws in the financial sector. There does seem to be some interest within Congress to consider stronger privacy measures, but there still seems to be tension in figuring out how to make that work, how to protect an individual's rights over their personal data that companies have previously regarded as part of their business. But what's clear is that people are paying attention to this. There's a lot more data privacy and data security activism around the world, including the US, and we will continue to see that play out in 2021.
Yeah, fascinating area with privacy standards. You know, a lot of it's so subjective. Different people have different privacy preferences. Tough to find a kind of a common standard that would be a good basis for legislation that applies to everybody.
Exactly.
Yeah. Now, Matthew, Veronica also mentioned GDPR. That's been around for a while now. Can you give us an update? What's going on with it?
Sure, Sergei, it has. I think one point on GDPR first. I saw a stat where the European Commission was saying that 69% of the population above the age of 16 in the EU have heard about the GDPR, which seems to be quite an extraordinary number for a piece of legislation. But what happened on the GDPR? Well, the 2-year review of the GDPR came out in June 2020 from the European Commission. It's a pretty self-congratulatory document, actually. They thought the GDPR had met most of its objectives. There were a couple of things that were pointed out. They thought there needed to be more uniformity in the application of the rules across the EU. And they need to ensure that citizens can make full use of their rights, notably the right to data portability. So a few things they pointed out, but that's an interesting document to look at, the 2-year review. Veronica mentioned Schrems. That is probably the most important data protection issue from last year in the EU and going forward. Very quickly, this invalidated the EU-US Privacy Shield, which was one way of ensuring legal transfers from the EU to the US in the absence of an adequacy decision. This was over, you may recall, concerns over the US government's bulk surveillance of data. And this is going to have impacts going forward into 2021. Companies need to use an alternative method. Veronica mentioned standard contractual clauses as also the binding corporate rules. But companies will need to make sure that these provide effective protection of data moving over. So transfer impact assessments will need to be carried out. And these are going to become commonplace, with companies needing to make sure that additional safeguards are put in place as necessary to ensure, if you like, the safety of data moving.
Well, very interesting. And definitely something to watch on both sides of the Atlantic. As Kayla said, there is some talk in the U.S. of federal privacy legislation. It'll be interesting to see if U.S. looks to GDPR either a positive example or an example potentially for some things to avoid. Definitely something
I think
to look for.
I think one of the really interesting things is to the extent you are hearing some clamor for federal legislation, it's coming from some sort of unexpected locations. I think a lot of you might expect privacy advocates to be the one that are really pushing for this, but I think that there is some concern that if there's U.S. privacy regulation, it may water down what's happening in California. So it will be very interesting to see how that all plays out. If we were doing this program 5 years ago, I think we would be thinking about, our thoughts on privacy really haven't developed. Privacy is now very much in the mainstream.
Very much so. So let's turn to our next segment now, consumer protection. And Lauren Aronson will kick that off with an update.
My name is Lauren Aronson. I'm a vice chair on the Consumer Protection Committee and a counsel in the Advertising and Media Group at Kroll and Mooring. I will cover the key consumer protection developments in the U.S. in 2020 and what to watch for in 2021. The COVID-19 pandemic has been the focus of significant consumer protection enforcement from both federal and state regulators. Beginning in March, the FTC sent more than 100 warning letters to advertisers making unsubstantiated claims that their products could cure, prevent, or reduce the risk of coronavirus, and more recently entered into consent orders. State regulators have enforced price gouging laws, investigated fitness clubs for charging membership fees during the shutdowns, secured ticket refunds for events impacted by COVID-19, among other issues. This year, the FTC revitalized the mail order rule. The FTC settled with online fashion retailer Fashion Nova and several PPE sellers for failing to provide required delay notifications and refunds. Made in USA continues to be a focus, and this year, the FTC published an NPRM for a Made in USA labeling rule. The FTC also continues to enforce the endorsement guides, entering into consent orders with tea marketer Teami and skincare company Sunday Riley for failing to disclose material connections. We expect to see changes at the FTC when President-elect Biden takes office in 2021. Biden has signaled that consumer protection will be a focus, and Vice President-elect Harris was formerly Attorney General of California. It may take some time to see a ramp up in enforcement. Currently, the majority of commissioners are Republicans. If Chairman Simons, a Republican, resigns, Biden would be able to appoint his replacement, who would then need to be confirmed by the Senate. One thing that will not change, state AGs, which expanded to fill the gap under the Trump administration, particularly during the period when there were only 2 commissioners. They will continue to play an active enforcement role. Thank you for listening.
So, Kayla, I want to turn to you for this one. Lauren touched on how the pandemic affected consumer protection. For instance, there was more emphasis on price gouging, of course, and also on unsubstantiated claims pertaining to products purporting to cure or prevent COVID. Do you think the pandemic will have any permanent effects on our consumer protection regime that will stay with us even after, the crisis subsides?
Sergei, it's clear that the pandemic has affected our lives in so many ways, and it has highlighted the importance of our consumer protection laws. At the beginning of the pandemic, I think all of us experienced frustration when we couldn't get the basic products that we needed or when products were available but at much higher prices. And as Lauren mentioned, federal and state regulators stepped in to curb the spread of false information and price gouging, and in the issuance of refunds to consumers where appropriate. Retailers have also stepped up their game this year in order to compete in the online marketplace. As a result, our consumer protection regime has also had to make sure that claims regarding products were accurate and that consumers could receive correct information. Another thing that we saw sort of in another area was that pharmacies expanded their mail order drug programs in order to give people access to the medications they need. And same with the availability of telehealth or health by video. So I think a lot of these responses will stay with us even after the immediate crisis of the pandemic recedes. And states will continue enforcing applicable consumer protection laws. As Lauren said, State AGs have really stepped up on this front whenever there was an absence of action at the federal level. And recently we spoke with the Colorado AG on our program. So people should go check out that episode to see what's going on in Colorado and how that's affecting us at the antitrust level and the consumer protection level. Lauren also mentioned that the incoming administration has expressed that consumer protection is a top issue. So I expect we'll see more changes when it comes to enforcement of consumer protection laws at the federal level.
Kayla, I think that's great. And one thing that I think all of this highlights is also the importance of everyone taking responsibility for protecting the privacy of consumers, whether that be the government or private companies. I think COVID highlighted just the many multifaceted ways in which people can get targeted, and how do you control the internet, and how do you control misinformation on the internet? And I wonder how much the government can do without the assistance of private parties as well.
Yeah, it's a very good point, Christina. All right, well, let's now turn to Jenna, who will provide us a consumer protection update on our neighbors to the north, Canada.
My name is Jenna Kramer. I'm a young lawyer representative on the Consumer Protection Committee and the Legal Counsel for Unilever Canada. I will cover important consumer protection developments in Canada in 2020 and touch on what to watch for as we head into 2021. It's impossible to reflect back on 2020 and not think about the profound impact of COVID-19 on consumer protection law. Provincial consumer protection agencies, Health Canada, Ad Standards, and the Competition Bureau responded to the pandemic by establishing tip lines for Canadian consumers to report advertising and price gouging incidents, and by publishing guidelines covering a wide range of topics, including substantiation for COVID-related claims, ads depicting group gatherings, and interim measures to expedite access to hand sanitizers and other disinfectant products. Aside from COVID-19, significant reform to Canada's privacy laws, both at a provincial and federal level, are occurring, including with the very recent announcement of the federal government's Digital Charter Implementation Act. The Digital Charter Implementation Act is an omnibus data protection bill that will regulate the collection, use, and disclosure of personal information, as well as aspects of AI, and establishes a new adjudication body, the Personal Information and Data Protection Tribunal. Looking into 2021, in my view, transparency in the digital economy will be of top priority for Canadian enforcement agencies. The Commissioner of Competition has identified digital services and online marketing as key sectors warranting the Bureau's focus, and has shared plans to launch the Bureau Innovation Garage, a platform for Bureau employees to experiment with and explore new digital technologies. As acting president of the International Consumer Protection and Enforcement Network, the Competition Bureau's driving theme for its presidency is building consumer trust in a changing marketplace. The Bureau has identified AI, digital platforms, and misleading fraudulent marketing activities related to the pandemic as the focus of its efforts. Thank you so much for listening.
So one thing that really caught my ear is the discussion of Canada looking to regulate AI. Kayla, is there any talk of anything similar in the United States?
Yeah, that was interesting. And this year, I would say we've seen an increased awareness about the artificial intelligence in our everyday lives, from facial recognition, autonomous vehicles, and online algorithms. So people are starting to see it, everywhere that they go. The regulation of AI is considered necessary in order to both encourage its development, but also to manage associated risks. So it looks like Canada has really stepped up on this front. In the US, it appears we still have very broad opinions when it comes to regulation of AI, but also deregulation in order to eliminate barriers for innovation. There have not been that many concrete proposals on this front. Some have suggested the creation of a federal agency focused specifically on AI. Other ideas have focused on investing and creating collaborations between government, academia, and the private sector. So it looks like discussions regarding the appropriate level of regulation of AI are going to have to continue in the US, and perhaps we can look to Canada as an example.
Well, I bet that's a topic we're going to continue discussing for many years going forward. And maybe next year in this program, we'll have something more concrete on the US side to sink our teeth into. Now, Jenna also mentioned Canada's focus on transparency in the digital economy. And Matthew, understand there has been some movement on that front in Europe recently. Could you fill us in on that?
Sure has, Sergei. We mentioned earlier the Digital Markets Act, but also announced on 15 December 2020 was the EU's Digital Services Act proposal. This is a complement to the DMA. They're intended to work together, but the DSA, or the Digital Services Act, focuses on issues like removing illegal content, goods and services, rules on traceability of business sellers online, issues like that. And it would introduce a range of obligations on these issues and other issues. It also includes a wide range of transparency measures, including on online advertising and the algorithms used to recommend content, transparency in relation to content moderation decisions, and the very large platforms will have additional transparency obligations, including external risk auditing and public accountability and issues, and also, in fact, will be required to share data with authorities and researchers under the Digital Services Act. So there's a lot going on in there. The Digital Markets Act itself also has some provisions on transparency. And as I mentioned with the DMA, these are proposals, so they're being lobbied hard, and a lot will happen on the DSA and the DMA and in this transparency sphere in 2021.
Yeah, so interesting with many different approaches being developed across the world. You know, the term that the state's a laboratory of democracy, you kind of see what different states are doing, pick and choose the best approach. Now we live in such a global world, it seems that not just the states, but different countries, different continents, a laboratory for developing different regulatory regimes. And we'll get a chance to see which ones succeed and which ones, are the ones to emulate going forward. Well, we listened to a lot of great content on privacy and consumer protection. So I just want to open it up to everybody. What are our folks' big picture takeaways on all of this? And where's this area of law headed in the next year?
So I guess I can go first. Just picking up on something you said, Sergei, I think you're absolutely right. I think what this discussion has highlighted for me is that the varied approaches to dealing with concerns regarding big tech, data, privacy, and historically, you would see coordination among states and regulators to ensure that their, parties aren't subject to multi-layered requests or standards. And I think it'll be interesting to see whether there is a coalescing of standards and laws across states in the U.S. and outside of the U.S. In the approach to regulating big tech and data, analyzing non-price effects and sort of which non-price effects matter, the approach to developing privacy and consumer protection standards. And does that mean, as John suggested earlier, that it's a race to the bottom, with some sort of lesser federal law, or is it a race to the top? So I think, maybe that issue won't come to head in 2021, but I do think it's something that will need to be addressed in the coming years.
Hopefully a race to the golden middle where we can weigh the different conflicting interests appropriately, but we'll see.
That golden middle is often very hard to achieve. I would, as I reflect on what we've heard today and reflect back on 2020, look, 2020, I don't think anybody is going to tell you it was a very hard year for everybody. And I think we in the U.S. confronted a number of issues, in terms of racial justice, in terms of a very divisive political year. But two issues I think permeated today and really permeate a lot of what we have been thinking about this year. One is obviously the pandemic, which has affected us in very many ways. And I think what we heard today was really about how the pandemic is driving concerns in a number of consumer protection and privacy areas. And I think there's going to be a lasting effect there. I think the pandemic has exposed some vulnerabilities that are going to have to be addressed going forward. And I think you'll see perhaps we'll see an awakening of some regulation in this space. But again, I think it was a very important factor. The other is, I think, more of a U.S. phenomenon than one in Europe or one in the rest of the world. But I think there was also an awakening to the dominant position of large technology companies, particularly the platform companies. And that we talked a little yesterday. I think we may even talk a little more tomorrow about the role that played in competition law. But again, as we talk today, so much of what we're talking about has to do with developments that are happening with technology, what we sometimes refer to as big data. And I think 2020 may be a year that we look back and remember as a pivot point in thinking about these issues.
Well, with Kayla,
I'll just add something to that. Yeah, I wanted to highlight what John mentioned about the pandemic sort of bringing a lot of things to everybody's attention. And, people have already gone digital. They've already been living their lives online for a while now. But I think more so this year because people had to stay home. So they had to go online more. And so issues when it comes to the processing of their personal data really came to the forefront. And so I think American authorities and private companies are going to have to keep transparency in mind, and especially when it comes to developing solutions to new issues that will come up next year in the digital economy.
Certainly makes sense. We live our lives so differently now than we did even a year ago. I mean, to get a little bit of inside baseball, recording this episode through Zoom. Everybody's doing everything through Zoom. And certainly people are using technology in a very different way. And that brings up a host of new issues that lawmakers and companies need to confront.
Yeah, Sergei, and maybe I'll just close out the episode with this story, which may or may not be a funny story. So early on in the pandemic, I was sitting I just finished up a Zoom call for business. I walked down the hall and there were my two younger children, both on Zoom classes in school. Walked downstairs, just my older guy on a Zoom class as well in school. And I look over and there's my wife and the dog taking an obedience class on Zoom. And that was the point where I realized we had crossed over. So thank you, everybody. Thank you, everybody, for listening to Our Curious Amalgam. We will be back with our next episode, which will close out our year in review. Until then, keep listening.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.